Good morning, Alex and friends. I'm Grace. Today is Saturday, June 7th, 2025, and you're listening to Alex's News. The weather in Riverside today will reach a high of 82.5 degrees Fahrenheit with a low of 62.3 degrees. It's shaping up to be a pleasant day, perfect for enjoying the start of the weekend. Later in the show, we'll dive into the details surrounding a significant development, why a specific agency, established during the Trump administration, is now able to access sensitive Social Security data. What does this mean for privacy and oversight? We'll explore the implications. Plus, we examine the recent decision in Southern California regarding gas appliance rules and unpack the reasons behind their rejection of these regulations. All this and more coming up on Alex's News. Stay tuned. We begin this morning with a significant legal development from the U.S. Supreme Court that could impact millions of Americans. Yesterday, the High Court delivered a pivotal ruling, temporarily allowing the Trump administration's controversial Department of Government Efficiency, or DOGE, to access highly sensitive personal data within Social Security Administration systems. For more, we turn to our legal affairs reporter, Ethan. Ethan, thanks for joining us. Can you walk us through the Supreme Court's decision?
Grace, it's a major development. In an unsigned 6-3 order yesterday, the Supreme Court granted the Trump administration's emergency request. This lifted a lower court's temporary injunction that had restricted DOGE's access to Social Security Administration systems. This temporary clearance, as reported by PBS NewsHour and CBS News, allows DOGE to proceed while the underlying legal battle continues. The case has now been sent back to the U.S. Court of Appeals for the Fourth Circuit for a ruling on its merits.
So, this Department of Government Efficiency, DOGE, is central. What is it, and why does the administration need this data?
DOGE, Grace, is an initiative established by President Trump on his first day back in the White House, January 20th, 2025. Its goal is to modernize federal technology and reduce government size. While billionaire Elon Musk initially led it, Russell Vought is reportedly the current head. The administration asserts DOGE's access is vital to target waste and fraud, particularly concerning alleged Social Security fraud. They argue this is key to getting the government to dig up efficiencies.
That's sensitive information. This decision wasn't unanimous. What are the privacy concerns raised?
No, Grace, it was not unanimous. Liberal Justices Ketanji Brown Jackson, Sonia Sotomayor, and Elena Kagan dissented. Justice Jackson articulated grave privacy risks for millions of Americans, criticizing unfettered data access without clear justification, as CBS News and PBS NewsHour reported. The Social Security Administration holds immense sensitive information, including Social Security numbers, medical, and financial data for nearly every American, amplifying these privacy concerns, as WVTM 13 highlighted. These concerns are far from a dog and pony show.
Prior to the Supreme Court, U.S. District Judge Ellen Hollander had issued an injunction. What was her reasoning?
Judge Hollander, Grace, described DOGE's efforts as a, quote, fishing expedition based on little more than suspicion of fraud. She had only permitted anonymous data access. Her ruling stated unfettered access would risk private information and concluded DOGE's access was unlawful, likely violating the Privacy Act. She felt they were barking up the wrong tree.
So who initiated this lawsuit?
The lawsuit challenging DOGE's access was filed by labor unions and retirees, represented by the advocacy group Democracy Forward. They argued unfettered access violated the Privacy Act of 1974. The Trump administration appealed, arguing the lower court overstepped its authority.
The administration's argument hinges on combating waste and fraud. How prevalent is it, based on official statistics?
Grace, it's nuanced. Most improper payments are not fraud. From fiscal years 2015 through 2022, the Social Security Administration estimated nearly $72 billion in improper payments. However, this is less than 1%, specifically 0.84% of the total $8.6 trillion in benefits paid. Confirmed financial fraud was $88.05 million in fiscal year 2023. So while improper payments exist, claims of widespread fraud needing such broad access are debatable.
And Ethan, another Supreme Court ruling yesterday also concerned Doge. Can you briefly touch on that?
Yes, Grace. On the same day, the Supreme Court extended a pause on orders to publicly disclose information about Doge's operations. This second case involves a lawsuit by the government watchdog group Citizens for Responsibility and Ethics in Washington, or CREW, arguing Doge is a federal agency subject to FOIA, the Freedom of Information Act. The administration claims Doge is a presidential advisory body exempt from FOIA. While the Supreme Court didn't definitively rule on Doge's status, it held that a lower judge had ruled too broadly, according to PBS NewsHour.
So what happens next in these legal battles?
As of today, June 7, 2025, the primary case returns to the U.S. Court of Appeals for the Fourth Circuit. The Supreme Court's stay on the injunction remains in place pending the Fourth Circuit's decision and any further appeals. The appellate court will apply the Privacy Act of 1974, focusing on no disclosure without consent and whether Doge members qualify for exceptions. The plaintiffs, Democracy Forward, remain committed.
Ethan, thank you for breaking down this very important and complex story for us. We appreciate your insights, and we'll be watching for updates. That's our first story for today. We'll be right back with more news after the break. Good morning, everyone. We begin this segment with a significant development out of Southern California, where efforts to clear the air have hit a bit of a roadblock. The South Coast Air Quality Management District, or SCAQMD, faced a pivotal vote yesterday on proposed regulations aimed at phasing out gas furnaces and water heaters. For more on this, we turn to our reporter, Chloe. Chloe, what exactly happened with these proposed rules?
Good morning, Grace. You're right, it was a crucial decision. Yesterday, on Friday, June 6, 2025, the SCAQMD Governing Board voted 7-5 to reject new rules that would have gradually phased out the sale of gas furnaces and water heaters across Southern California. This vote was the culmination of 2 years of development for these proposed regulations, known as Rules 1111 and 1121, according to reporting from LAist and the Los Angeles Times.
So they were rejected. That's a bit of a setback for air quality advocates, isn't it? What was the primary goal of these rules, and why are they considered so important for the region?
Absolutely, Grace. It's a significant development, especially for a region that frequently tops lists for smog. The main objective of these rules was to drastically cut down on emissions of smog-contributing nitrogen oxides, or NOx, from natural gas appliances. NOx is a major component of the persistent smog issue in Southern California, and it's linked to serious health problems. We're talking about respiratory issues, severe asthma attacks, decreased lung function in children, and even premature death. As NBC Los Angeles reported, citing the Associated Press, the SCAQMD, which oversees air quality for over 16.8 million people across Orange County and large parts of Los Angeles, Riverside, and San Bernardino counties, estimated these rules could have prevented nearly 2,490 premature deaths and over 10,200 new asthma cases over a 26-year period. It really puts the stakes into perspective.
Those numbers are staggering. So even though they were rejected, what was the proposed timeline for this phase-out, and how would it have worked for consumers?
Well, Grace, the plan was quite ambitious, yet gradual. According to the Los Angeles Times and LAist, the proposed phase-out aimed for manufacturers to reach 30% zero-emission sales by 2027, which is about 1 year and 7 months from today. That target would then jump to 50% by 2029, or approximately 3 years and 7 months from now, and ultimately hit 90% by 2036, which is over 10 years down the line. While traditional gas appliances would still have been available, manufacturers exceeding these targets would have faced pollution mitigation fees. The Los Angeles Times detailed these fees: $100 for each gas furnace and $50 for each gas water heater sold within the compliance targets, escalating significantly to $500 and $250 respectively for sales beyond the cap. The idea was that this revenue would then help subsidize zero-emission appliances, especially for residents in disadvantaged communities, making the transition easier on the pocketbook for those who might struggle.
That sounds like a carefully crafted plan. So, with such clear public health benefits and a structured approach, why did the board ultimately vote against it? What were the main points of opposition?
That's the million-dollar question, Grace. Opposition was both intense and multifaceted. A primary concern, voiced by opponents like board member Janet Nguyen, who is also an Orange County supervisor, was the potential financial burden on consumers and businesses. As NBC Los Angeles and the Los Angeles Times reported, she explicitly stated that the rules would target people, specifically 17 million homeowners, renters, seniors, and small businesses, by making appliances more expensive. There were also significant worries about the strain on California's already stressed electrical grid if a widespread shift to electric appliances occurred.
And I understand there was also a significant legal threat that played a role.
That's right, Grace. It was a pivotal factor. U.S. Attorney Bilal Bill S. Saleh, a Trump administration prosecutor based in Los Angeles, directly threatened to sue the board if the rules were adopted. He asserted on X, "Feds set energy policy, not unelected climate bureaucrats," according to LAist and the Los Angeles Times. Several board members cited this legal threat explicitly as a reason for their no vote. Beyond that, appliance manufacturers and utilities, including SoCalGas, had actively lobbied against the rules for months. The California Apartment Association, or CAA, also opposed them, arguing they were preempted by federal law and imposed unjustifiable compliance costs. They even criticized the SKQMD for overstepping its authority by including recommendations on tenant protections.
So a gas leak, if you will, in the legal argument. It sounds like a real battle between state and federal authority. What do the supporters say about these rules and the legal challenges?
Indeed, Grace, it's a very hot topic right now, legally speaking. Supporters, including SCAQMD board members Holly Mitchell and Linwood City Councilman Juan Munoz Guevara, argued that these rules are absolutely essential for improving Southern California's air quality, which consistently fails to meet federal standards. As the Los Angeles Times reported, they asserted that gas appliances are a significant source of pollution, and that these measures represented an overdue step toward environmental justice that would save lives and, quote, correct decades of pollution burden. They also pointed to potential long-term financial benefits, with the Telegraph reporting that the Air Quality Agency estimated annual savings for residents between $191 million and $250 million from 2027 to 2061, if the rules were adopted.
A big debate, to say the least. What happens now? Is this the end of the road for these regulations?
Not quite, Grace. Despite the rejection, the board immediately voted to send the rules back to committee for further changes and reconsideration. This means the debate isn't over, but as the Los Angeles Times has indicated, any future vote on a revised version is unlikely to occur before next year. This whole situation unfolds within California's broader, aggressive pursuit of environmental standards, like the aim for net zero carbon emissions by 2045, which is about 19 years and 7 months away, and the existing plan to ban the sale of new gas-powered cars by 2035, about 9 years and 7 months from now. It's a very politically charged issue, and we can expect more legal skirmishes ahead.
So not a total combustion of the idea, but a temporary cool down. Chloe, thank you for breaking down this complex and important story for us. We appreciate your insights.
My pleasure, Grace.
We have been discussing the SCAQMD's decision on gas appliance regulations. Sources for this report include LAist, the Los Angeles Times, NBC Los Angeles, the Associated Press, and the Telegraph. Here are some other headlines. In Washington, Senate Republicans are attempting to reprogram their approach to state-level artificial intelligence regulations. Facing significant backlash to an outright 10-year ban, they've revised a controversial provision within a broader tax bill. Now, instead of a direct prohibition, states that enact their own AI laws could see federal funding for broadband projects, specifically from the BID program, debated. The new proposal, part of a framework released June 5, 2025, would offer $500 million in FY 2025 for AI infrastructure development, but only to states that agree to pause AI regulation enforcement until 2035. Proponents like OpenAI's Sam Altman argue this prevents a confusing, quote, patchwork of rules, while Senator Ted Cruz says it will unleash America's full economic potential. However, a bipartisan coalition of over 260 state legislators and 40 attorneys general are crying foul, worried it strips their power to address AI harms like deepfakes and algorithmic bias. Critics, including Anthropic CEO Dario Amodei, call the 10-year moratorium too blunt, especially without a clear federal plan, creating the worst of both worlds. Polls suggest this AI power play is unpopular with voters, and even some House Republicans like Marjorie Taylor Greene are expressing unease. The revised provision is also an attempt to navigate the Senate's Byrd rule by linking it to federal spending. Meanwhile, a complex legal saga has seen Salvadoran immigrant Kilmar Abrego Garcia return to the United States, nearly 3 months after he was wrongfully deported. The Trump administration, which had previously stated there was, quote, no scenario for his return despite court orders, admitted the March deportation was an, quote, administrative error. Abrego Garcia, who held a, error. Abre Padarias Superative Aereo status, due to fears of gang persecution in El Salvador, was initially held in a notorious supermax prison there. Now back on U.S. soil, he faces a 2-count federal indictment in Tennessee for alleged alien smuggling dating back to 2016, with prosecutors claiming he made over 100 trips and transported Mississippi 13 members. The administration alleges he's a Mississippi 13 member, a claim his lawyers vehemently deny, pointing out he has no prior convictions. Attorney General Pam Bondi has made further uncharged accusations, while Abrego Garcia's legal team calls the charges preposterous and an abuse of power, suggesting the administration was playing games with the court. His arraignment is set for June 13th. Looking skyward, it was a cratering disappointment for Japanese company iSpace, as its private lunar lander, ironically named Resilience, crashed during its landing attempt on Friday, June 6th. This marks the company's second failed lunar mission, after the Hokuto R Mission 1 also crashed in April 2023. Communication with Resilience was lost just moments before its scheduled touchdown in the Mare Frigoris region. Preliminary analysis suggests a delay in the lander's laser rangefinder, obtaining valid measurements, prevented it from decelerating sufficiently, leading to a quote, landing. The lander, launched in January 2025, carried several payloads, including a European Space Agency mini rover named Tenacious. While iSpace CEO Takeshi Hakamada apologized and vowed to analyze the data, he also acknowledged the company doesn't have infinite funds for repeated failures. South of the border, significant concerns have been raised about Mexico's historic judicial elections held on June 1st, where voters selected nearly 3,000 federal and state judges. Championed by President Claudia Sheinbaum as a way to root out corruption, the process has drawn criticism. The Organization of American States highlighted an abysmal voter turnout of just 13%, widespread lack of voter awareness, and the prevalence of cheat sheets often guiding voters towards ruling Morena Party candidates. This has led to fears of a politicized judiciary, with the OAS noting doubts about the new Supreme Court's autonomy. A high percentage of null and unmarked ballots, exceeding 10% and reportedly reaching 23% in some counts, signaled a protest vote. Changes also relaxed judicial candidate qualifications. The election, marred by some campaign violence, is seen by many as a victory for Morena, potentially consolidating its power and eroding Mexico's democratic checks and balances. And finally, The U.S. State Department has clarified that current U.S. visas held by individuals from 19 countries affected by a new travel ban, signed by former President Trump and effective June 9, 2025, will not be revoked. The ban imposes a full travel suspension on 12 countries, including Afghanistan, Iran, and Somalia, and partial restrictions on 7 others like Cuba and Venezuela. However, a cable from Secretary of State Marco Rubio assured that visas already issued prior to the effective date should not be revoked. While this offers some relief to current visa holders, new visa applications from these nations, even if approved but not yet issued, will be denied starting Monday. The Department of Homeland Security will still have discretion at ports of entry. The ban, citing national security and inadequate vetting by the listed countries, includes exemptions for lawful permanent residents, dual nationals using other passports, and diplomats, among others. That's all we have for now. Today's episode was made by Alexander King with Claude Sonnet 4.0, Gemini Pro 2.5, Gemini Flash 2.5, and Google Cloud Text-to-Speech. I hope you have a great day. I'll see you tomorrow, Alex.